Hello and welcome to the latest instalment of the Mountford Chambers Regulatory and Professional Discipline webinar series. Today we're discussing the regulatory regime of the Teaching Regulation Agency, also known as the TRA. We'll start with a few introductions. I am James Lloyd, Deputy Head of the Mountford Chambers Regulatory and Professional Discipline Practice Group. My practice spans a number of professional disciplines and regulatory regimes, including healthcare, teaching, policing, and finance. I'm joined today by Sadie Thompson, Associate at JMW Solicitors. Sadie, I wonder if you'd like to introduce yourself and tell us a bit about your practice.
Hi, as James has said, I'm an associate in our business crime and regulatory team at JMW Solicitors. I've been at the firm for about 7 years now. My practice covers various regulatory bodies, including TRA proceedings, as we're talking about today, but also police officers and doctors, nurses, things like that. So yeah, I'll pass on to Jim to introduce himself.
Hi, I'm Jim Olphert. I'm counsel at Mountford Chambers. As with James, I have a broad practice in regulatory proceedings, including teaching, tax, finance, healthcare, and policing.
So the TRA, perhaps a little bit about it to start. I think it was April 2018, the TRA took over responsibility for the regulation of professional discipline within teaching from what was then the National College of Teaching and Leadership. I wonder if we could start perhaps with Sadie again. Would you like to tell us a little bit about what the TRA does and when it will typically become involved?
Of course, so the TRA are the regulatory body that are responsible for regulating the teaching profession. They investigate where appropriate matters of misconduct or wrongdoing within the teaching profession, and they conduct the investigations and then assist in determining whether matters should progress to a formal panel hearing where consideration will be given to whether a prohibition order should be granted. And I understand that Jim will speak about that a little bit later on. So the TRA regulate the vast majority of teachers. This includes teachers in both state and independent schools, but also in institutions such as sixth form colleges, children's homes, youth accommodation. Some home tutors will be covered, but not all. So if people do have any concerns about whether or not they would be covered by the regulations, then it's worth looking into. So concerns will be investigated by the TRA when a referral is made to them. So various different individuals or body can make such referrals, including employers, which is where it tends to come from. So from the school itself or the institution where the teacher is working, but also the police can make referrals, the disclosure and barring service, or members of the public. So for example, students or parents can make the referral as well. The TRA will investigate any allegation of serious misconduct. So that includes inappropriate relationships with pupils, misconduct in an academic sense. So for example, if pupils are kind of given unfair advantages in terms of examinations and things like that, financial misconduct, so misappropriation of funds at the school, any sort of dishonesty, bullying allegations, and also criminal behaviour, which I'll touch upon in a little bit. This should be contrasted to kind of competency issues. So if there's concerns as to the competency or the ability of the teacher itself, that's not an issue for the TRA. That is something that should be dealt with internally. So there's a distinction to be made there. So the first step, and where I often get involved as a solicitor, is the initial investigation stage. So what will happen, the person that is being investigated will receive a letter from the TRA, well, their representatives, because they will instruct firm solicitors themselves to advise that a formal investigation is ongoing. Quite often the teacher will have some awareness of it through the school anyway. So the school will probably alert the teacher to the fact that a referral has been made. So it's not usually the first time that the teacher is hearing about it. So the investigation takes place. This can take varying kind of lengths of time, depending on the nature of the allegation. But so the teacher will be advised that an investigation is taking place and that they should expect to hear from the representatives in due course. The TRA's representatives will then carry out the investigation, which can include, so it's the evidence gathering stage. So they will obtain witness statements from students or other staff members, parents, and they will gather various other documents that will assist them in their investigation. For example, employment contracts, any email correspondence, notes from meetings, and they will put together that bundle. The teacher will then receive the formal bundle, which will include the allegations themselves and will set out exactly what is being alleged and then the evidence that is being relied upon. The test that is being applied by the representatives when they're conducting the investigation, and also it's the test that will then be applied at the later stage if it does reach a hearing, is whether the actions of the teacher amount to unacceptable professional behaviour, whether the action of the teacher brings the profession into disrepute, or whether the teacher has a conviction at any time for a relevant offence. So that's a criminal conviction. There isn't a kind of hard and fast rule or a list of what offences would be deemed to be relevant. That is a matter for the TRA's representatives to assess, or at a later stage, a panel to assess. So it will be for the teacher to demonstrate that it's not relevant and that it shouldn't affect their ability to act as a teacher. So examples of offences that may not be relevant are more sort of minor motoring offences and things like that. But other than that, it's fairly strict. And these tests it can be either or. The TRA's representatives wouldn't have to establish that all three are met. It can be one or the other. So once the teacher receives a copy of the investigation bundle, they will have an opportunity to respond. Usually they're given 28 days to provide their response, but it is possible to request extensions if that's going to be necessary. Although there has to be a good reason for requesting it. For example, if you're waiting on materials, rather than just having not got around to it, essentially. So it's quite a quick turnaround in terms of having to get the response together. This is a really, really important document, and the teacher should give proper consideration to what goes into it, because it's the first formal account that is being provided, albeit accounts may have been provided at the school if they've conducted an internal investigation. And if it does go to a panel hearing later on and there are any discrepancies, or the teacher provides a slightly different account at a later stage, then that can be drawn upon to test sort of the accuracy and the truth of the contents of the response. Yeah.
Because what we often see is that teachers, when they're facing internal disciplinary either procedures or investigations, are often told that they cannot have a legal representative at a school level or a board level. And so we often see a lot of documents prepared, interviews or notes of meetings, where there was no lawyer. And this process starts without legal team's involvement. And as you said, the teacher is informed that they're under investigation and evidence is collected before lawyers or solicitors or barristers get involved. When, in your experience, is it best for teachers to lawyer up, as it were, to seek assistance and advice?
It's really difficult because, like you say, early on, internal investigations are carried out, and a lot of the time, teachers want it resolved as soon as possible, and they need to, and often want to be seen to be cooperating. But like you say, sometimes the difficulty arises because a teacher said something in a more informal setting at the school, and they quite often have sort of union reps there, but these people aren't necessarily legally qualified, and it's an experience that most of these teachers haven't been through before. So although the teacher wouldn't necessarily be able to have a lawyer in the meeting itself, my advice would always be to try and get someone involved really early on, because we can always give sort of preemptive advice. We wouldn't necessarily have had sight of all the documents or accounts that have been provided by students or teachers at the school. But we can give some sort of general advice which would assist them in any meeting that they had. And then it means that if we then got involved at a later stage, if there was a TRA referral, we can ensure there's that consistency with the account that's been provided early on. And I understand, obviously, that it's daunting to get lawyers involved, and it's and lots of the time teachers want to sort of deal with it in their own way. And I think there's sometimes this stigma that once you've got a lawyer involved, it sort of ups the ante slightly. But it's work that we would do at that later stage anyway if there was a TRA referral. So it's not really a duplication of work. It just adds that level of security from really early on.
And I think one of the features of not just this regulatory regime, but many, and I think we'll touch on this later, is that investigations, with the best will in the world, can take several months, referral to the regulator several months, preparation of the hearing several months, waiting for the hearing several months. And I'm sure, Jim, perhaps you might have the same experience here. One often finds that when you get to a final hearing, a teacher's recollection of events is relatively poor because they haven't had the guidance at the time or closer to the time to keep particular records or keep memories fresh. Jim, what do you think people should be looking to do when concerns are raised at the time?
Well, James, as you say, I think really it comes down to keeping a good record, not just in terms of documentary matters, which of course, if the case involves documents, seems fairly self-explanatory, but also just keeping that careful notes of what happened. And as with any regulator, albeit the TRA has, as I'll touch on later, different sanctions options open to it, not just what's happening and what their recollection is of those events, but also how that's impacted them, how that's impacted others. Because when it comes to a discussion about ultimate sanction, if we get to that stage, the teacher being able to demonstrate that kind of reflective work from a very early point can be invaluable.
I also think it's worth highlighting that sometimes, and we will talk about it, sometimes it results, the referral itself or the incident that's happened results in either the teacher being dismissed or often choosing not to work at the school anyway because they feel that they're not able to, even if there's not sort of an interim prohibition order in place. But they don't always then have access to the materials that they would have done at the time. So, for example, I've got cases where we're then reliant on the school providing that material, which there are opportunities to request that disclosure, but then you put all of that in their hands. And obviously you need to be slightly conscious, especially if there's sensitive information in the material or confidential information, but at least then having a note of what material is available there, because sometimes I speak to the teachers and I say, what is available, or do you have evidence that will support this account? And they say there is, but I don't know what dates these emails were sent. I don't remember who it was sent to. I just remember having discussions about it. So also from that early stage, keeping a note of what is in existence can help us then request that from the school.
And I think sometimes that's exacerbated, certainly in cases I've seen, where schools, or particular schools, have a very high turnover of staff. You can often find yourself in the position of wanting to ask a head of year, a head of department, particular questions about particular incidents, only to find that they've moved school years ago, no longer have access to documents or emails, or even have left the profession as well. And so, Sadie, I think that ties into what you were saying about the importance of preparing a detailed response at the outset.
Yeah, absolutely. And like I say, you get 28 days initially, but sometimes it does take a long time to put these responses together, and it does need to be thought about carefully. And leading on from what we've just been talking about, one of the really important parts of this early response is providing material to support the account that is being given. And that can include requesting disclosure from the school, which feeds into what we were just speaking about, but also obtaining statements. So character statements, generally to the teachers, general character or how they were in the profession, how they're regarded at the school. But also sometimes it can be important to obtain statements of fact as well. If there have been other teachers or colleagues or TAs, for example, that have been present when the incident happened, getting those people on board really early on is so important, because like you say, their recollection will go over time. And if we can get a statement from as close to the incident happening as possible, it means if you do need to rely upon these people at a later stage, they've got that reference point that they can look back on. Also, in terms of what should be submitted with the response, any sort of evidence of mitigating circumstances, if the teacher was having a particularly difficult time in terms of medical or family issues, it's good to get material that we can provide to support that. The response itself is really important to give consideration to what to potentially making admissions if the teacher accepts that something has been done wrong. It's not necessarily the case that if people make a mistake that they're going to be dismissed. And actually, a lot of the time in professions like this, and we get it in all regulatory work that we do, the integrity of the teacher is so important. And if they are able to hold their hands up and say, yeah, okay, I made a mistake on this time, I accept that I didn't act as I should have done, but I've learned from the mistake, or it was a training issue, then that can be resolved. The TRA aren't out to just sack people for the sake of it. And it's a lot more of a sort of collaborative approach than perhaps general criminal matters are. And so having that sort of awareness of where things have gone wrong and accepting where the profession can learn from that is really important. And I think sometimes when people haven't been through this before, the sort of first thought is, well, I just need to deny this in its entirety. But actually, it's really important to get legal advice early on as to the importance of kind of making those admissions, and also how to frame them and how to use a form of words that puts it across in the best possible way. So I'll just go on to finally speak about what happens after we put the response in. So we as solicitors sometimes will get barristers involved at this very early stage, and we'll put together the response and send it to the TRA's representatives. They usually, unless there's a huge amount of material, they're pretty quick at considering it, and they will have a meeting to determine how matters should progress. If they accept that the test that I spoke about earlier isn't met, then that will be the end of the matter. It won't be referred to a hearing, and that will be the end of the case, which demonstrates just how important this early stage is. Alternatively, the TRA's representatives may decide that there's a case to answer here, and that it does need to be investigated more thoroughly, and a panel need to make a determination on it, in which case it will be referred to a professional conduct hearing. Jim will speak about it later. That doesn't necessarily mean that the teacher is going to be dismissed. There's various options open to the panel to make a recommendation. So it's not that all is lost if it gets to that stage. But that's the position that the teacher will then find themselves in, and they will receive a letter confirming what the outcome is. So it's not sort of just left in the ether and the teacher's just wondering when it's going to crop up again. They will be alerted either way. So that's the investigation stage. I think that's everything I have to cover on that.
And I think that leads us on to what we like to call the interim stage, and the period between the TRA receiving a concern and deciding what to do about it, and indeed reaching the final hearing if the matter goes to it. One of the features of the TRA regime, which is different to other regulators in different sectors, is the TRA's powers and the Secretary of State's powers in respect of interim orders. And one particular difference is that there is no such thing in this regime as interim conditions orders. Healthcare regulators, for example, have conditions of practice. Other regulators have restricted practice orders. In TRA proceedings, the only interim order available is an interim order of prohibition, preventing a teacher from teaching or engaging in educational activities at all. And in every case where the TRA receives a referral, the TRA must, within 3 days, triage that case and decide whether an interim prohibition order is necessary. What happens if the TRA decides that an interim prohibition order is necessary is that they will inform the teacher and necessarily the teacher's representative. Normally that will be done very quickly, and the representatives and the teachers will have 10 days to respond. That 10 days is not an absolute rule. It can be extended by agreement. And as Sadie was saying earlier, the TRA is a relatively pragmatic regulator and really does have at its heart the aims of protecting students and upholding confidence in the teaching profession. Where further information is necessary to make a risk assessment, so for example, where a teacher has been charged or arrested on suspicion of a serious criminal offence, extensions to that 10 days can be granted to gain more information from the police or the CPS. But on receipt of that information, whether it's in 10 days or later, within 5 working days, the TRA must make a decision, and that decision will be communicated by the Secretary of State. The cases in which interim prohibition orders typically apply are the very most serious cases, cases involving criminal conviction or investigation for serious criminal offences, invariably involving some form of sexual abuse or a nexus with children. Where the order is imposed, it takes effect immediately, and the teacher can no longer act in any educational setting. It takes force quite literally the minute it is made, and it's published, as with all prohibition orders, on the Teacher Service Restriction List, which all schools can access through the DFE portal. Perhaps unusually, in respect of a prohibition order of any form, there is no right of appeal to the High Court of an interim prohibition order made by the Secretary of State. That's not to say, however, that if you are made subject to an IPO, that you have no recourse. The TRA must review interim prohibition orders at least every 6 months, and in practice we know that they review them more regularly at every stage when new evidence comes to light or when queries are answered. But not only does the TRA have an obligation to review, but those subject to interim prohibition orders may also request a review. Firstly, within 6 months of the imposition of the order, and then every 6 months thereafter. So there is still a real benefit to be had by engaging lawyers, even if you are prohibited on an interim basis from practicing in teaching, because it does not mean that you will be prohibited throughout the process. Things do change, and often we see when charging decisions are made, for example, the TRA takes a more pragmatic view. And that leads us perhaps on to what other things we need to be doing in the interim, waiting for a hearing. Jim, I wonder if your experience matches mine on this, but it seems to me that the TRA is quite similar to other regulators in that the regulated professionals can expect to wait well in advance, or much more than 6 months for a final hearing.
Absolutely. It can be a long wait, and it can be a frustrating wait for at least 6 months until final hearings are listed. It can be, whilst of course the teacher will know that the case is being investigated because they'll have had that notification, sometimes whilst the process is slightly more collaborative than it would be in, say, a criminal process, sometimes you can go a fair while without hearing anything from the regulator, and that can be disarming. But as I'm sure you're about to cover off, James, that doesn't mean that we should sit on our hands from a defence perspective. There's plenty that we can do in the meantime to start getting the ball rolling in terms of putting forward a decent case on behalf of the teacher.
Exactly so. My view is, in most cases, the more time you have awaiting final hearing, the more you can do to prepare yourself for it. And this is where proper engagement really matters, and where proper preparation will pay off in the long run. Obviously, the preparation for every final hearing involves consideration of the evidence, what evidence there is, what evidence there is not. And the TRA, as with other regulators, will disclose the existence of material it is not using, that it has collected but does not consider relevant. That is material which the regulated person and their legal team must review properly, because as we know, context invariably is key, and a lot of academic concerns about teachers' behaviour in a particular educational setting often has a lot of context which can go unnoticed without proper investigation. There are a lot of pressures on teachers on a daily basis, not just through workload or learning environment, but as Sadie touched on, personal factors. The more you can scrutinise the circumstances of alleged wrongdoing or misconduct, the more information you will have to be able to present to the panel to contextualise what happened, and ultimately, as Jim's going to touch on, to influence, as far as one can, the ultimate outcome in the case. Consideration also has to be given at a relatively early stage about what the hearing will look like. The TRA, like many other regulators, holds hearings both remotely and in their offices in Coventry. There's no steadfast rule on how a hearing must proceed, but there's a general approach at the moment that I think around 50-50 is my recent experience. Jim, is that the same for your recent cases?
Yeah, absolutely. I'm certainly seeing, compared to the last couple of years, where obviously as a result of the pandemic, things have been primarily online, I'm certainly noticing a far more even split now, and a move back, certainly by the TRA and other regulators, to more in-person hearings.
And when considering what the hearing will look like, we don't just have to consider where it will be, but what evidence will be presented. And that's when, as Sadie was mentioning earlier, prior preparation of evidence really matters. Regulated people can use this time to collate character evidence, contextual evidence, but also evidence of reflection, of insight, explanation, and remediation. all of those things are often of immeasurable benefit to regulated people at the end of a process, even where things have gone wrong or where something has happened that ought not to have. For a regulated person to be able to say, yes, that shouldn't have happened. I've reflected, and this is why it did happen. And I've thought further, and this is why it wouldn't happen again. And I can prove that to you by this learning, this reflection, this adaptation, this change. All of those matters take time to think through, to strategize, and to evidence. And that's where proper engagement of the legal team is of particular importance. The legal team will also be involved on the defence side, and indeed as they are on the presentation side, in the drafting of witness statements. And in my experience, it's really quite important to ensure that witness statements are as thorough and on point as can be. A good character witness will go a very long way. A good witness statement from somebody working in the same school or educational institution, talking about the context, how things were at the time, what the work pressures were like, what the working environment was like, what supervision felt like at the time for an independent person, is of great assistance to many panels when they're considering how and why particular things happened. Now, of course, we've touched on admissions, and the interim and the run-up to a hearing is also a time to consider whether admissions are going to be made. And as Sadie said, often demonstrating integrity and contrition is far more productive for regulated people than blanket denials. Where a teacher admits allegations and when they accept, which is the later stage, that those admissions and factual occurrences amount to either a conviction for a relevant offence, unacceptable professional conduct, or conduct that may bring the profession into disrepute. What will invariably happen is that the TRA will draft themselves a statement of agreed facts. That will be sent to the teacher and the teacher's representative in an effort to agree all that matters in one document, to present to a panel at the end, and to reduce not only the length of the final hearing, but often the need for the calling of witnesses. Ordinarily, and the aim is that that statement of facts will be provided to the regulated person no later than 4 weeks after their response to the allegations. But this is another example of a document which proper thought, care, and the assistance of legal representation will make a huge difference. Because as with any statement of case or witness statement or pleading, this is a document that frames the issues. It frames the issues for the panel. It is going to be the centerpiece of their reasoning, of their understanding of the case. And in our experience, proper engagement of a legal team when drafting and agreeing a statement of facts can make a huge difference to the outcome in the case. A statement of fact will often be quite skeletal when received by the teacher. It doesn't have to be. It's down to the teacher and their legal team to add in that which they think is necessary to contextualize, which is important information, or which is not otherwise contentious. And so again, Sadie, I wonder if this marries your experience, but certainly from my perspective, an agreed statement of facts can be one of the most powerful tools when it comes to mitigation in a final hearing.
Yeah, absolutely. And I think, like you say, it contextualizing it and helping the panel to understand how this incident has come about or what has led to this situation just really helps the panel to then make a judgment on how best this should be dealt with. And like anything, if you just put the bare bones of it, it can look a lot more jarring, and it can, anything in isolation, it's easy for people to reflect and look back and say, yeah, that sounds awful, that's taken place. And like you say, the TRA are there to protect students, but also everybody's human. People make mistakes, and a lot of the time there is reasons behind that, and that context and adding to that in the statement of facts is so important, in helping the panel to appreciate that and to consider how the teacher has reflected upon it. And it just then provides that sort of skeleton that can then be drawn upon when you are mitigating for the teacher at that later stage.
I think that draws us on to what happens when we finally get to the hearing. Jim, do you want to talk us through what hearings look like and what the potential outcomes are before the TRA?
Thanks, James. Yeah, absolutely. And just before I do, just to tag on a brief matter about witnesses generally, my recent experience has been, and perhaps this issue will eventually be ironed out, but at the moment it seems to be causing some issues before the TRA, where witnesses are abroad, which is in our global world increasingly common. There is now a pressing need to make sure that there is some kind of agreement from the Foreign and Commonwealth Development Office, or FCDO, and particularly the taking of evidence unit there, about permission for that witness to give evidence from abroad. And certainly people I've spoken to anecdotally, and also in some of the hearings I've done recently, this has either derailed entire hearings or caused significant delay as a result of preliminary issues, and that invariably is something that's worth boxing off early. So just wanted to add that rider on in the pre-prep stage. So what then does the hearing look like? Well, the process and procedure of everything the TRA does from the investigation stage all the way through is, of course, governed by the Teacher Misconduct Disciplinary Procedures document, which is found on the government website. Those procedures changed in 2020. And as with other regulators, panels are generally bound by the procedures in place at the time of the conduct. So if the conduct dates back some years, you will sometimes be reminded gently at the hearing that, of course, you need to look at both the new and old rules. They are also, fortunately, still available on the TRA website. As James has touched on already, cases are still frequently dealt with a mix of remotely and in person. Those in-person hearings generally will take place in the TRA offices in Coventry, but as with all regulators, I'm sure they would take account of matters were that not the case. But certainly that is becoming a more frequent thing to consider is the location of the hearing, whereas during COVID it wasn't. It's always heard by a panel, as the others have already alluded to, and that panel has a specific constitution. It has to have at least one teacher member, and a teacher member has to be someone who either is presently a teacher or has been a teacher within the last 5 years. They also have to have at least one non-teacher member, and you'll have guessed from the way that the teacher member rules are described, that has to be someone who has never been a teacher. The third panelist can be a non-teacher, a teacher, or indeed someone who was a teacher but no longer qualified to sit as a teacher panelist because that 5-year time limit has passed. As with a number of regulators where the panels don't have a legally qualified member sitting on the panel are assisted by a legal advisor who plays no active role in the decision making, but can advise on matters of law and procedure, and will be invited to do so regularly by the panel. And in particular to the TRA, it is also suggested within the disciplinary procedures document, can advise on the interpretation of departmental policy to the extent that that becomes relevant to any given hearing. Before I go on to talk about the stages, I just wanted to pause there and bring James back in for a moment on the benefit of engagement and understanding between the legal representatives on both sides and also the legal advisor. James, you'll of course have some experience in this. How do you go about approaching making sure that matters are on all fours between all parties, so that the legal assessor or legal advisor doesn't give advice which is either prejudicial to your client or generally unhelpful to the process of the hearing?
I think I would say that as a general rule, the legal advisors employed by the TRA are, in fact, without exception, very good and also very approachable. I think with all cases, it's always useful to have a proper chat between the representatives and the legal advisor before the hearing starts. And one thing that one notices in TRA proceedings is often, particularly where there are multiple teachers involved, not all of the representatives will be lawyers. Some teachers represent themselves, some have union representatives. It's often very useful to have a chat before a hearing starts to set some ground rules, to work out where there is common ground, and also to narrow the issues as much as you can. Often things get lost in translation in written communications, and I find that when one turns up to a hearing and has a chat with the other side and the legal advisor on the morning of day one, it becomes clear that there are fewer issues than perhaps you might have envisaged. And that extends to the legal advice as well. Identifying with the legal advisor from the outset where the difficulties in a particular case may lie, or which particular pieces of evidence may be problematic in terms of objections, of hearsay, of character and whatnot. I think identifying those early on often makes the process a lot easier. And Jim, you'll have noticed this as well. Every hearing starts with a scripted opening from the chair. And part of that opening always seems a little bit jarring, but the TRA is always at pains to explain that this is not an adversarial process, but is intended as far more inquisitorial in nature. And Sadie's touched upon it as well. It seems to me that as a regulator, the TRA does take a genuinely collaborative approach, and panels seem to reflect that in the way they approach hearings as well.
Absolutely, James. I think that's entirely right. And I think all the more reason why it's important that you're on an even footing with the other parties in the hearing, because ultimately, if it's inquisitorial, as the TRA wish it to be, then it's the panel that will be setting the agenda, and all parties should be trying where possible, not just for the effectiveness of the hearing, but also generally for the benefit of your client, to be pulling in the same direction and helping the panel answer those questions which they doubtless have in their mind going into the hearing. As with all regulatory proceedings, the hearing is approached in stages. The panel must first establish findings of facts, and it's at that stage that, generally speaking, the bulk of witness evidence will be heard. After they've done that, they then proceed to determine whether that amounts to one of the statutory grounds which have already been touched on. Importantly, just to bring this back in, as Sadie mentioned towards the end of her comments, unlike some regulators, there isn't a competence ground at the TRA. This isn't about your effectiveness as a teacher. This is about whether or not you have committed something which will bring the profession into disrepute or is seriously unprofessional in scope. And that really frames what happens at that stage onward of the process. Not only is there no competence grounds, but as we've also already touched upon, the only real specific sanction that you'll hear about in the lead up to any hearing is prohibition. I'll touch on that more in a moment, but there are, of course, other options open to the panel. And one of the things that's important in any TRA hearing is to make sure that just because the matter has got over that hurdle of amounting to conduct which can bring the profession into disrepute or unacceptable professional conduct, that you don't simply take your hands off the steering wheel and say, well, the outcome is predetermined, because of course it's not. So the fact stage, well, the burden of course lies with the TRA at the fact stage, and the standard of proof is balance of probabilities. That's the same across nearly all the regulators. And as with other regulators, the decision as to conduct and to prohibition are matters which are almost exclusively for the panel's judgment, though in respect of prohibition, that's slightly more complicated than it would be in front of another regulator for reasons I'll come on to in a moment. Neither of those latter two stages have a burden and standard, though panels will plainly be advised, both by the legal advisors and doubtless the parties, about the seriousness of making those findings and the significance on them, both for the teacher, but also for members of the public. Dealing with a couple of procedural matters very briefly, panels will have to deal with the service of the notice of hearing at the start, as in any regulators, and as with any regulator, they have the power to proceed in the absence of the teacher. They'll follow the usual general case law in reg cases in terms of proceeding in the absence of a teacher, including balancing that fairness, allowing the teacher to participate, but also the need for regulatory proceedings to be expeditious. As James has already touched upon a moment ago, the disciplinary procedures set out in the disciplinary procedures document are fairly rigidly adhered to by panels, and to a greater or lesser extent, unlike in some regulators, panels appear to follow the script pretty closely. That, of course, is good because it guarantees consistency across panels, but it is something that I think can wrong foot people when they go in, because they expect it, on the basis that it's collaborative, to be a bit more conversational, but there is nonetheless still that element of formality that needs to be respected. Common to other education regulators, but less common to regulators in other fields like healthcare, is the fact that the representative for the teacher or the teacher themselves can, at the outset of the hearing, make an opening address which sets out and narrows the issues. That isn't something which other regulators necessarily do fairly frequently, because their processes perhaps mirror a criminal trial in format, if not in scope, a little bit more closely. But I've found, and again, James, bringing you back in if I may, that opportunity to address the panel early before the calling of evidence, when read alongside the statement of agreed facts, can be a really useful tool when defending teachers, to narrow the issues and to frame the way the case is going to be presented all the way through, so that the panel have a useful early taste of cases as a whole.
Absolutely. I think it's always useful, and indeed any good opening should, to signpost the panel to what it is that they need to consider with the greatest care, where the areas of dispute, if there are areas of dispute, are. And you're right that an opening address, along with that statement of facts, can be very powerful for either side, setting out what it is exactly that the case turns on and where the areas of dispute are. Otherwise, one can sometimes see panels faced with what are sometimes bundles going to the thousands of pages, starting a hearing on the back foot. And sometimes that can come across as panels being slightly short or defensive. I think helping a panel in that inquisitorial and collaborative way often reaps rewards for both sides.
Absolutely. Once those openings have been done, as I've touched upon already, the next logical stage at facts is to hear evidence. It would be a rare case, though of course they do happen, where there are no witnesses at all, and certainly at least the teacher is generally going to give evidence. Touching briefly on evidence for a moment from the teacher perspective, in my experience, however well put together a witness statement might be ahead of time, there is always nonetheless benefit in the teacher giving oral evidence to a panel. First, that gives the panel an opportunity to answer questions which they may have for the teacher, maybe scant or maybe many, but it gives that opportunity nonetheless. But also, touching again on something which both Sadie and James have drawn upon, there is a real need in these processes, as there is in a great many jurisdictions, but particularly ones where one person and their conduct is the focus of the particular hearing in question, to contextualise that person's actions, but also to put flesh on the bones, to make clear that this isn't just a statistic or an allegation, but a real three-dimensional person that the panel have to assess and read their character generally, but also their demeanour, why they reacted the way they did. And for me, that is drawn out most effectively through good live evidence before a panel, which can then impact not only findings of fact, but also the panel's ultimate decisions down the line. So moving on to those decisions, we've buried the lead a little bit in terms of talking about prohibition a few times in this webinar, but the ultimate outcome open to the TRA is to prohibit the teacher from being able to continue teaching. That decision is taken unusually by no party to the hearing at all, and that will come as some surprise to those listening who haven't worked in TRA proceedings before. But in short, the process is that the panel will hear submissions on prohibition as they hear submissions at every stage, and will take account of what evidence they have been directed to. But all that they then do is make a recommendation. And that recommendation, once it's been considered by the panel, either to prohibit or not, is sent through to the TRA and the Department for Education, and it's the Secretary of State, or more fittingly, a delegate of the Secretary of State, who makes a specific decision about prohibition. I find that certainly representing teachers, that stage of the process can be quite unsettling. You certainly have a bit of a steer from the panel about where they're going from the written decisions and oral decisions you've had to date. But the fact that the case finishes without a resolution can be quite a distressing thing for the teacher to have to reckon with. The decision itself, when it's made, can be total. It can be an ongoing prohibition for the rest of the teacher's career, but it can also be time limited. At the minimum time a prohibition can last for is 2 years. And unlike something like a suspension order in front of other regulators, it isn't automatically diminishing. That's to say, it doesn't stop after that 2-year period. You would still have to reapply. But that time limit, which the panel will make a recommendation on to the Secretary of State, can, in my experience, provide some comfort. And certainly teachers who face prohibition and receive a prohibition order, but limited only to the shortest possible period, 2 years, are faced with the prospect that if that's a career which they want to continue with, and as Sadie has mentioned when talking about teachers leaving schools when investigations go on, that isn't guaranteed, but certainly many teachers obviously want to continue in their chosen profession, and where they only have 2 years and then they can reapply, that gives them an opportunity to build a bundle of evidence together so that after that 2 years has passed, they can apply to rejoin. James, Sadie, bringing you both in on the issue of prohibition. James, I'd be interested to hear your views on how you've approached the question of prohibition with teachers when you're representing them, and framed the risks and the jeopardy, but also the potential time limits. And Sadie, how you frame it when you speak to clients at an early stage, what you talk to them about when you say, these are the ways that the TRA can approach cases, and how teachers feel and can react to that.
I think, Jim, you you touched on the key point from the defence side, which is unlike so many other regulatory hearings. A TRA final hearing ends with no discernible outcome for the person who was subject to it. And those teachers that I've represented have, I think, without exception, found it very difficult to realise, okay, that the hearing's over, there's nothing more any one of us can do. Now we wait. Experience suggests that, in fact, the Secretary of State or delegate is actually very quick in adopting or rejecting the panel's recommendation. I think that the quickest response I've had recently was 48 hours. I don't recall having waited for more than 4 days for an outcome from the Secretary of State in the last couple of years. But it's certainly something that teachers find distressing. But as you've said, the prohibition is not forever and ever amen in most cases. Even in some serious cases, prohibition orders lasting 5 years still give scope for readmission to the profession at a later date. And again, that's when engagement with legal teams and experts can also be of use to establish what the plan is after a prohibition. What evidence needs to be gathered, what needs to be done, and what that teacher can show the regulator in due course to demonstrate that they are worthy of re-entering the profession on the footing they were on before. But it is a particularly difficult step for clients. And Sadie, I'm sure your clients have found it difficult as well.
Yeah, you've both touched upon it, but this is the clients we represent. These are almost the worst thing that they can be going through at a time. And I think we have the same experience with any regulated body that we regulated profession that we represent, but these people have worked a long time to get to this point. They've trained really hard to get to this point, and there's this now thing that's looming over them that it might be taken away from them. And as we've touched upon, they're not particularly quick processes, and people can have this hanging over them for 6 months, a year, maybe longer, depending on how long the investigation stage lasts. And it's a really hard time for people. That said, from a solicitor's perspective, we have to be pretty open with people early on as to what the reality of the situation is, and providing people with sort of, I don't want to say false hope, but making sure that clients are aware of what options are available to the panel is really important. That said, I think a lot of the documentation that you receive early on refers only to a prohibition order, really. It's consideration is being given to the issuing of a prohibition order. It doesn't necessarily go into the detail of what that can look like in reality, as you've spoken about, that it might be 2 years, it might be 5 years before teachers can reapply. And I think that's really important to explain to people early on, because otherwise they can lose sight of sort of the fight and the importance of dealing with this properly, and engaging solicitors and engaging counsel at that early stage to help you through that process. Because if teachers think that this is all or nothing, and either I'm going to lose my job and I can never be a teacher ever again, or I can carry on as normal, you then lack that sort of learning exercise, and there's potentially more reluctance to accept where there has been wrongdoing, because there's this fear that it will result in your entire career, essentially, and everything that you've worked for being taken from you. So it's really important that as the legal team, we explain in layman's terms what the reality of the situation is, whilst ensuring that things are put in place. Because ultimately, if a prohibition order is put in place for 2 years, then it's important for the teacher to have considered what they're going to do in that time period, and how they can learn from it, and how they can develop and reflect, so that they put themselves in the best possible position to re-enter the profession in 2 or 5 years, if that is what they want to do.
I absolutely agree, and I think it's always worth noting that it's not a foregone conclusion. The wording of the letters from the TRA, I agree, Sadie, sometimes gives the impression that maybe the issue has been predetermined in some way. And of course, the benefit of having legal representatives is that not only can they represent you at the hearing if it gets that far, but they can also talk you through the realities of the process. Two final tag-on points I just wanted to deal with in respect of prohibition. First, as I've said, it's not a foregone conclusion, and increasingly the prohibition guidance talks about the merit of simple publication of a decision regarding unprofessional conduct being sufficient, what they describe as censure punishment in some cases where there's been clearly a lot of work done by the teacher, a lot of time has passed, whilst the panel might make adverse findings at facts of misconduct. That doesn't mean that they should be prohibited at all, and in fact publication can be a remedy in and of itself. And the final point I just wanted to make on prohibition is my experience recently, and James, feel free to jump in on this too, but my experience recently is where orders are made or recommendations made by the panel, which are for shorter time limited prohibition orders, that there is something of a trend, as there might be in front of a regulator making a suspension order, to give some context to their decision, yes, but also to steer the teacher perhaps a little bit in terms of what the panel or any future panel might look for before readmission. And representatives teasing that apart can sometimes help the teacher with a steer of what's next and how to build that back to a positive position.
I agree with that entirely, and I think it ties into perhaps the most characteristic feature of the TRA when compared to other regulators. Given the TRA's proximity to the Department for Education, its interaction with the Secretary of State, and the interplay of that relationship, and also the very keen involvement of teacher members, what's quite clear is that this is a regulator that is rooted in the profession. It's far less divorced than some regulators can perhaps appear, and there does genuinely, in my experience, seem to be a desire to improve the profession and to retain talent or to regain talent where possible. And I think in that sense, perhaps giving the final say to Sadie, there is often a lot of hope to be gathered at the end of the process for those who go through it and either have findings which exonerate them or who are not subject to prohibitions.
No, I agree. And I think a lot of the time you get to the end of these processes, and particularly because you don't get a final decision at the hearing itself in terms of sanction, and teachers will often, even if they are exonerated, will feel like there's just going to be like this sudden euphoria that they're now through this process. But actually, the process itself is very difficult and can affect teachers, even if it's found that it doesn't meet the statutory test, or that a prohibition order shouldn't be put in place. It's still a difficult experience to go through, and it's still a real learning curve for teachers. And the investigation itself, and what the kind of actions of the teacher that have formed the subject to this investigation, will still form a huge learning exercise for the teacher. And vice versa, if a prohibition order is put in place, it is about placing the teacher in the best possible position to be readmitted in years' time, if that is what they want. And it's about kind of the reflection and the learning exercise from this. It's not, the TRA proceedings don't kind of start and finish with when you get the letter and when you finish the final hearing. It's an ongoing process that will affect the subject of it for years to come, and it's really difficult. And so it is about kind of like, that's why our instruction early on, and a lot of the time our instruction even after the hearing, can be so important.
I agree entirely. And I think, having avoided educational puns for the last hour or so, it's time to ring the lunchtime bell. And thank you both for your time and your expertise. Sadie Thompson from JMW, Jim Olphert from Mountford Chambers. This has been the latest instalment of the Mountford Chambers Regulatory and Professional webinar series, and we hope to see you soon.